Good morning. I'm Gary DeWaal, and this is Bridging the Week for December 11th to 15th, and today is December 18th, 2017. Last week, the Securities and Exchange Commission said it had no appetite for not considering a digital token issued as part of an initial coin offering to support an iPhone food app, a security subject to regulatory requirements applicable to all securities, while the chairman of the SEC issued a personal statement cautioning about ICOs. Separately, the Commodity Futures Trading Commission issued a proposed interpretive guidance to clarify when financed offers and sales of virtual currencies to retail clients would be subject to regulatory requirements that ordinarily apply to all futures contracts. This is the season of many holidays and the release of The Last Jedi. So I can celebrate all and see the latest in the Star Wars saga. Let's get started. The SEC filed and simultaneously resolved an enforcement proceeding against Munchee Inc. for conducting an initial coin offering constituting the unregistered offer or sale of securities. Munchee agreed to cease and desist from its violations to settle this matter. It was not required to pay any fine. The company voluntarily returned all funds it had received from token purchasers, namely $60,000 US. On the same day the SEC issued its Munchee order, SEC Chairman Jay Clayton released a personal statement addressing cryptocurrencies and ICOs. Although acknowledging that some cryptocurrencies may not be securities, he cautioned, quote, market participants against promoting or touting the offer and sale of digital coins or tokens without first determining whether security laws apply to those actions, end of quote. Solely labeling a token a utility token or a currency is not sufficient, he said. Generally, Mr. Clayton noticed, quote, tokens and offerings that incorporate features and marketing efforts that emphasize the potential for profits based on the entrepreneurial or managerial efforts of others continue to contain the hallmarks of a security under U.S. law, end of quote. Munchee had developed an iPhone application for persons to review restaurants. Beginning in October 2017, it offered and sold digital tokens, known as MUNs, to be issued on a blockchain to raise $15 million US to fund development of the app. According to the SEC, Munchee claimed in its promotional efforts that MUN tokens would rise in value as a result of the firm's managerial efforts and that MUN tokens would be traded on secondary markets. Although Munchee described utility benefits of possessing MUNs in promotional materials and other marketing efforts, for example, the more MUNs a person held, the more MUNs it would receive for writing restaurant reviews, the principal benefit of holding MUNs was the potential for appreciation of the value of MUNs through Munchee entrepreneurial efforts. As a result, concluded the SEC, MUN tokens were securities, and Munchee's offer and sale of MUN tokens without a registration statement being filed with it, absent a bona fide exemption, was illegal. Last July, the SEC published a report of investigation that concluded that digital tokens issued by an entity for the purpose of raising funds for projects, even if using distributed ledger or blockchain technology, may be securities under federal law. There is nothing in the Munchee order or Mr. Clayton's statement that is fundamentally inopposite to guidance given in the SEC's DAO report. However, these two writings make clear that marketing a digital token as a utility token and untethering a token from the earnings of a company are not sufficient to make the token a non-security. A cryptocurrency will still be regarded as a security if its holders purchase a token with the expectation that it will rise in value, principally based on the managerial efforts of others. The CFTC issued a proposed interpretation that would formally require actual delivery of a virtual currency to a retail client within 28 days to avoid commission registration requirements by persons selling or either financing or arranging financing of the virtual currency. Although the CFTC does not typically regulate spot transactions involving retail clients, retail commodity transactions on a leveraged or margin basis or financed by the offeror, the counterparty or a person acting in concert with such persons on a similar basis may implicate certain commission requirements, namely registration requirements by the offeror and a requirement that the products be traded on or subject to the rules of a designated, meaning licensed, contract market. The key is whether actual delivery of the commodity has occurred within 28 days of the transaction. If yes, CFTC registration and other requirements are not implicated. If no, CFTC registration and other requirements are implicated. In its proposed guidance, the CFTC said that, consistent with prior guidance involving retail transactions of tangible commodities, it will consider quote-unquote actual delivery of a virtual currency to have occurred when a customer can take, quote, possession and control, end of quote, of all of the cryptocurrency and use it freely no later than 28 days from the date of the initial transaction and can do so unencumbered. This will require neither the offeror nor seller or any person acting in concert with such persons retaining any interest or control in the virtual currency after 28 days from the date of the transaction. And finally, the CFTC proposed an order authorizing 3 ICE derivative clearing organizations to invest customer funds in certain euro-denominated sovereign debt instruments issued by France and Germany. The 3 ICE entities are ICE Clear Credit LLC, ICE Clear US Inc., and ICE Clear Europe Limited. The proposed order would also permit the 3 ICE DCOs to engage in repurchase transactions in the relevant French and German sovereign debt. Prior to the collapse of MF Global in 2011, such investments were permitted by CFTC rule. However, in 2013, the CFTC amended the relevant rule to prohibit investment of customer funds in non-U.S. sovereign debt. Under the proposed order, the CFTC would impose a number of conditions on the ICE DCOs, investment of customer funds in French and German sovereign debt instruments. I have always regarded the CFTC's prohibition of future commission merchants and DCOs to invest in the qualified sovereign debt of non-U.S. countries as an overreaction to the collapse of MF Global and an unfair imposition of currency basis risk on such entities. Currently, if clients deposit euros with an FCM or DCO, the entity must first convert such currency to U.S. dollars in order to purchase approved U.S. dollar-denominated obligations. What the CFTC is proposing for the ICE DCOs is sensible and includes more than adequate protection for customers. However, this expansion of investment authority should not be restricted to the ICE DCOs. It should be expanded to all DCOs as well as to all FCMs and can be considered for other non-U.S. sovereign debt instruments. Well, that's it for this week's edition of Bridging the Week, which is also the last regularly scheduled Bridging the Week for 2017. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a great week, happy holidays, and until the next edition of Bridging the Week next year, ciao. Oh, by the way, may the force be with you.